which were obviously untruthful and relied on a complete mischaracterization of the document.
Was there any evidence of the presence of Sarasin-Alpen in Switzerland?
No, Sarasin-Alpen didn't have a presence in Switzerland.
So there wasn't a Sarasin-Alpen desk in
No.
the...
No, Switzerland is Bank Sarasin. That's common ground. Switzerland is just Bank Sarasin. The next example I'm not going to take you to, but it's just so you'll know.
I think that's it. Alpen Capital is the joint venture partner, is it? Or is it something else?
No, yes.
Yeah.
Alpen Capital is probably the thing. And so you have Sarasin-Alpen here and Bank Sarasin in Switzerland. The next one, just
so Alpen Capital hasn't got a presence in Switzerland either?
No.
Okay.
Next one is at page 166. I'm not going to spend any time on. I just say for my submission, the judge's comment again entirely justified, given how the evidence had gone. The next one was at page 189 to 191. Another fair intervention in my submission. The passage starts at page 189, and it's about suitability. At page 190, at lines 8 to 13, Mr. Alia says, no, we were told by Mr. Alia that this is the kind of investment she likes to do. She's got stocks, bonds, she's got bank accounts, credit suite agency, what have you. She does investments in all kinds of products. And this is what they thought was suitable for her. And then question, is this more speculation about what Mr. Taha would have said at meetings that you were not at? Answer, no, this is not speculation. Again, ultimately the term sheets were signed off by her when they were sent to her. She got the account opening. So he's rather ducking the point that it clearly was speculation. 191 then, lines 2 to 3. Question, what are you actually yourself aware of in terms of investigations of her financial position or financial understanding? No, I personally was not. So after giving me answers which again looked like evidence but they weren't because they were speculation, he ends up, it's another example when pressed, he accepts he just doesn't know, he wasn't aware. And that's why the judge intervenes at 191, saying, just pausing there, the last passage, about the last minute and a half, is another rather bad example. Witness failing to tell me whether this is something he knew or he supposed or was told by Mr. Nair. Endemic theme which runs through this evidence, which I have inadequately sought to avoid. But when we get this sort of answer, I'm completely in the dark of whether this witness is telling me something which is told by Mr. Khorafi or by Mr. Taha, or whether it's some information that's been related to him by Mr. Nair, or whether he's simply assuming this is what happened. And then the judge makes the point, I then raised the point that as I understand it, he's saying it was speculation, and of course that's certainly my case, that what he's saying is speculation. And the judge then says, can we keep an eye on it? Which is what he says at page 192, lines 13 to 20. And then, unfortunately, Mr. Alia goes ahead on page 193 to give another piece of speculation, where he starts saying things about things that would have happened, about the bank not dreaming up information, and which I then have to pick him up again, 193, lines 15 to 18, and the judge, having just given a warning, has to comment on it again. Again, entirely appropriate judicial intervention in the face of a very difficult, evasive and speculative witness who indulged in speculation. The last example for my learned friend was the intervention which relates to the passage at H3 200. Sorry, the document at H3 200. 201. 201, I apologise. 83201. Now, this is not an easy document for me to explain the point very quickly in front of the Court of Appeal, but it was a document that we spent quite a lot of time on at trial, and it was a significant point of the trial. And the bottom line is that this document, especially page 26709 of the document, made it clear that as of June 2008, Bank Sarasin, for collateral calculation purposes, included the liability to ABK under any commitment to ABK. That's the point that one derives. It is a little bit of a cold towel job to try and present on this kind of appeal in this way, but what one derives from page 6709 is that this document shows the inclusion of ABK commitments. And the reason it does is because of that line which says coupon payment to ABK. And that was included in, and because of that, the point was that while it was unclear to what extent this was a sort of new approach by Bank Sarasin and what they'd done all along, because the documents didn't tell us, what it plainly showed is that they considered that they were able to treat a commitment by Bank Sarasin to ABK as being something you then just treat as a liability, which you then calculate, you then place in the balance for margin calculation purposes. And if that was the approach, that shows that even the first tranche was underwater from day one, and the second tranche even more so. And so that was why I was going to a document and exploring it with Mr. Alia. And the passage of evidence is in tab 57, page 43 through to 45. Sorry, D2, I'm sorry, it's D2 still, tab 57, page 43 through to 45. Thank you. And this is preceded, and I certainly can't take time going to it now, I'm afraid, but it's preceded by a long passage. It starts at page 31, and it starts at page 31, line 17. And I cross-examined for the whole of the next 12 pages about this document, getting out the point I've just explained to my lords. That's the purpose of the cross-examination over that whole 12 pages. And I will invite my lords after this to read those passages, and the conclusion I submit one draws from them is that Mr. Alia could see where this was going, this cross-examination, and he was, throughout this passage, being as evasive as he could be in the answers to my questions about this document and the implications of this document. And once one gets to page 44, by which stage one had 14 pages of transcript in this, the judge said, I shall have to look at the transcript and take a view either the witness doesn't understand the question, or that if he does understand the question, he's simply not going to answer it. And that was an entirely fair intervention. The judge wasn't in fact committing himself either way on that. My submission would have been, and still is, that he was in fact, he did understand the questions that were being put, and he was just not going to answer them. I can't take it very far by reading those passages right now, but that is, one needs to read the whole of that extract starting at page 31 to see how it ran. Now, and that really takes me to the more general point. That's the last of my learned friends examples. If the Court of Appeal were minded to get into any of all of this, I would simply invite them to read the whole, as indeed my Lord Sir David Steele said he's going to do. You need to read the whole of Mr. Alia's testimony, and you will see a thoroughly evasive witness, and the judge being, if anything, a model of restraint. And of course, I've been through only my learned friend's examples. If I had the time, I'd have liked to have gone through Mr. Wiley's evidence to give my own examples. But even on my learned friend's examples of a judge being unfair, one could already see quite how evasive and difficult Mr. Wiley was. Now, my learned friend didn't orally develop his other so-called examples of a judge taking an unfair approach, which he mentioned at paragraphs 46 and 47 of his skeleton. So I'm not going to go to those either. There's nothing in them. There's just one point I will pick up on, which is the suggestion that the judge was unfair at the quantum, at the post-judgment hearing, when he made the observation about the defendant's abandoning points. What my learned friend didn't explain to my lords is that in the run-up to that hearing, both defendants were taking the position, and it was in their skeleton arguments, that the judge, in his judgment, had awarded nil compensation. They were saying that was the construction of a judgment, which was an absurd proposition. On the eve of the hearing, once we'd all got to Dubai, we discovered they were abandoning that position, and they were conceding the judge did intend to award some compensation. The judge would have prepared for the hearing on the basis that this was going to be their submission, and they abandoned it at literally the last minute. That was the context of why the judge made the observation about the defendant's abandoning points. So again, as with all of these examples, in their context, nothing unfair or surprising about any observation from the judge. Now, I apologise for taking up a bit of time on that area, but it is a matter of concern, because the my learned friend's challenge is centrally founded on an argument of unfairness on the judge's part. But the only unfairness here is in my learned friend's submissions, because they take what the judge has done out of context, and they are unfair criticisms of the judge who has behaved entirely appropriately. And another point on this is the defendants haven't, of course, mentioned the other interventions of a judge. This is something else you'll see when you read the transcripts. This is a judge who does intervene from time to time and likes to keep abreast of what's going on in his court and likes to keep control of it. My learned friend has picked a few examples which he says didn't treat his side very nicely. There are a number, which you'll see when you see the transcripts, where we had some interventions that we didn't particularly enjoy. That's just how this judge, perfectly fairly and appropriately, conducts his proceedings. And none of this comes close to establishing anything that can get any headway in my submission on an appeal. Can I now go to ground 1.1, which is their target, which is the judge's actual findings about what was said at meetings?
Sorry, you're turning to what?
Their ground 1.1, which is their target. Ground 1.1 in their notice of appeal, which is the target they're trying to hit with all of their criticisms of a judge's process. And what the target they're trying to hit is to say the judge's findings about the claimant's requirements and what was said at meetings was wrong and should be upset. So that's where I'm now coming to. And for the reasons I've gone through, I suggest there's nothing remotely irrational or wrong about those findings. My learned friend says they are against the inherent probabilities, but that's just not right. And there's 5 points, I think, here. First, as regards the inherent probabilities and the contemporaneous documentation, my learned friend had his schedule, which he went to, of contemporaneous documentation, but all of those were documents which were expressly considered by the judge and generally dealt with him, in particular in the narrative section of his judgment. Nothing material was overlooked. Secondly, the suggestion that the judge failed to test the evidence against the documents is an improbable and unrealistic assessment of what the judge actually did, and Mr. Brindle's approach is wrong in principle and falls entirely into the Howson and Nicolaisen fallacy of suggesting that everything that's not set out verbatim and into every part of the judge's reasoning that isn't set out fully in the judgment suggests he didn't take something into account. And my learned friend is in reality asking you to go down a road you should not go down. After every trial, I'm sure my lords will have had the same experience when they were at the bar. After every trial, the reality is that the losing party gets the judgment and thinks, why didn't the judge make more of this fact or that fact? Why isn't this episode dealt with or given more prominence? And you can't use that as a ground of appeal. Otherwise, all of us would be trying to appeal every trial we ever do. And every judgment would need to be 10,000 pages long and wouldn't take 13 months to complete. It would take about 3 years. That's why the Court of Appeal, that's why all the judicial explanations of what the approach is on appeal say what they say. And the judge's approach was one that was open to him. I'm still on my second point, and if you like, there are just 3 sub-points on this. Sub-point 1, the requirements and understandings were essentially a matter of the meetings because they were not communicated in writing. Secondly, on the meetings, sub-point 2, the judge heard and believed the claimant's evidence, and most of it was unchallenged, and the requirements were essentially accepted by virtue of being put to Mr. Al-Khorafi, as I've said. Thirdly, the defendant's witness on the meetings also essentially accepted the case. He accepted the claimants wanted capital protection, a coupon which would meet the interest, and some return. He also accepted the claimants wanted no risk. And on that question, that last question, the claimant's evidence was unchallenged. Sub-point 4, none of the documents... I'm afraid my points and sub-points may have become a bit lost, but sub-point 4, none of the documents showed any different understanding on the part of any of the claimants. There was no email or similar from any claimant showing any different understanding. And sub-point 5, and this is rather a long sub-point, but it's an important one, insofar as it's now said that other documents, in other words, not documents not showing the claimant's understanding directly, but just other documents, are inconsistent with them having the understanding. There was nothing that was compelling, and this was all a matter for the trial judge to weigh against the other evidence as he did. And I'm going to give some examples. If the point is that the product literature explained the product, as my learned friend submitted, the true position was that the fact sheets, which were the only intelligible documents, were misleading and supported the claimants. The other documents, the term sheets, were difficult to understand as the judge found. So nothing there meant the claimants couldn't have had the understanding they professed or were not made the promises they were. Next point, my learned friend asked rhetorically, why would Sarasin-Alpen have made such promises? Well, the answer is they were puffing the product. And we've already seen, just from the evidence, and only a smattering of the evidence we've looked at today, that they have a habit of puffing. That's what they do. They exaggerate and they puff. And Mr. Walia's own evidence is that he actually thought there would be no problem in meeting the coupon while protecting the principal. So he thought it would all be all right. And I gave my lords the reference to that yesterday. So it's not particularly startling that a man who puffs his products would have made the representations he did. Now, still in relation to documents, there were other documents that my learned friend relies on, which are just internal documents in the sense of being Bank Saracen documents, or documents going to ABK. None of those help on the question of what statements were made at the meeting and what the claimants were given to understand. And the last category of document my learned friend relies on is documents showing what Mr. Taha was sent or what Mr. Taha may have thought he understood. Now, there are a number of important points here. Mr. Taha was not the client.
Was not?
The client. He wasn't any of these 3 clients. Next, the key events on the claimant's requirements happened at meetings attended by the claimants. Attended by Mr. Al-Khorafi, one of which Mr. Taha did not attend. Next, Mr. Taha's actual role has been greatly exaggerated by the defendants. The judge made a finding about this at paragraph 165 of his judgment, where he rejected it's a 165. He says, I accepted evidence he had no dealings with Mrs. Hamad or Mrs. Rifai. He never met either of them. I reject the defendant's attempt to portray Mr. Taha as an expert advisor to Mr. Khorafi or Mrs. Hamad or Mrs. Rifai in relation to investments generally or structured financial products in particular. I accept he had no relevant experience in relation to the investment decisions that were made in this case. That is the judge's findings, rightly, we say, in relation to Mr. Taha, which my learned friend overlooks in his submissions. And paragraph, I'm not sure one needs to turn this up, but just to note, at paragraph 341 of the judgment, the judge also rejected the contention that the claimants were content to rely on advice from Mr. Taha. So he was a go-between, and only to a certain extent. And as the judge found, he never even met the second or third claimants. So it wasn't even really the question whether he understood the product. That wasn't the question for the judge. But even if that had been the question, in fact, on the evidence, you couldn't reach any safe conclusion that Mr. Taha understood the product. It was clear to Bank Sarasin he didn't understand very much. Bank Sarasin suggested he went on a derivatives course. The documents generally showed him not to be particularly sophisticated, and this was, again, one might need to read it, but it was demonstrated in spades when he was cross-examined. This was not a sophisticated man by any means at all. There are other points in relation to Mr. Taha, which are recorded at paragraph 338 to 340 of the judgment, just for your note. And as regards the documents relied on by my learned friend, what one can see from the documents is that Mr. Taha was actually asking for explanations about how the product worked, and the high watermark of my learned friend's submissions was the exchange of documents showing Mr. Taha trying to produce his own version of how the product worked. But what he produced is itself difficult to understand, and it turned out to be wrong. And it turned out to be wrong by many millions of dollars, as was shown by the document that came back, which is at bundle H2148. But in any event, all of these documents were explored in cross-examination. And so the judge was perfectly entitled to reach the conclusion he did, that as regards the claimants and their requirements, they were as he found. So I apologise for my point numbering. I think it was actually 2 points, the second of which had some sub-points. Sorry, I apologise for that. Now, my learned friend next says this is all against the probabilities more generally, but again, this overlooks the extent to which Mr. Alia made admissions that in substance reflected the claimant's case, and it ignores Mr. Alia's explanation of his own rationale, we say, for the puffs that he made, which is he thought it would all be all right and the returns would be achieved. The suggestion was next made by my learned friend that the judge was not entitled to regard Mr. Alia as an unreliable or evasive witness. Now, I think that wasn't pursued with particular vigour by my friend. I think my learned friend now does accept he was unreliable. I think he might still quibble about evasive, but as we've seen, even in my learned friend's examples, he was as unreliable and as evasive as one gets. That leaves just 2 criticisms which I haven't dealt with in relation to Mr. Alia. One is the judge's paragraph 181. And the example that the judge gave was evasive, and again one needs to read it in its context, but it was certainly evasive. The question was whether, insofar as they were making a recommendation, Sarasin-Alpen needed to ensure the product was suitable, unless they could rely on an exception. The answer should have been, and always had to be, yes. Mr. Alia tried to avoid it by saying we don't recommend products, we give generic advice. Now that answer was in fact untrue, because there's extensive recommendations, as we'll see. But leaving that aside, the answer was evasive, because it didn't answer my question. So the judge was right in the conclusion he made about that, although he could have chosen many other examples. And in fact, one way of testing how evasive it is that according to the first defendant's skeleton, paragraph 48.4, they think that Mr. Wiley was answering no to the question, whereas actually the only answer could have been yes. So it's actually quite a good test of how evasive it is. Now, the next one from a learned friend is paragraph...
Now that's referring, is it, to the extracts from the transcript?
Yes, so you can...
Identified in paragraph 181. Could
Yes.
you just cross-refer those for us?
Yes. So it's 23rd of May, which is... will be in D1... No, sorry, D2, tab 55. First, yeah, D2, tab 55.
Thank you.
There's then... The next criticism is on paragraph 197 of the judgment. And that's a reference to the meeting cross-examination, which my learned friend suggests that what the judge found about Mr. Wiley's evidence about the meeting was perverse. And I've been taken, my lords, already to the transcript, and the defendants completely gloss over how the evidence actually ran, and why Mr. Wiley's evidence about that meeting of Mr. Taha was entirely unsatisfactory. Do you remember that was the episode where he said he was there, he wasn't there, said his witness statement was right when he didn't know, and then eventually admitted it was wrong.
Unusually the word perverse is used throughout the application for leave to appeal and the skeleton in support of it. I'm assuming that it does not mean, as might at first blush be suggested, that the judge deliberately made decisions contrary to the evidence.
Well, I have to ask my learned friend.
Certainly not. No, perverse.
It's an unusual word to use.
Well, yes, but one's attacking the findings of
I've
fact.
never seen it before in an appeal skeleton, challenging findings of fact.
Certainly not intended to be
The
deliberate.
usual context in which the judge might use the word perverse is when a jury returns a verdict which is manifestly and deliberately intended to avoid applying the law. But there it is.
Well, no, I think perverse.
Anyway, I assume that it simply
this
means
context
that
is no,
it's inconsistent with the weight of the evidence, which is, I'm going to slightly put in the alternative. Okay.
Well, no, not quite that. No reasonable judge could have found it.
A sort of Wednesbury unreasonable.
Yes, that's the word, the sense in which perverse is often
Okay.
used. Like you clarified, certainly not intended to go any further than that.
But it's just how it struck me when I first read it. Yes.
There's then the point I think I've dealt with about the judge's conclusions about Sarasin-Alpen's motives. That's a particular reference to paragraph 432 of the judgment.
432.
432. It's right at the end of the judgment, where the judge said he's satisfied the presence is a clear case of mis-selling unsuitable investments from an unsophisticated investor into his equally unsophisticated wife and mother. That was carried out by employees of Sarasin-Alpen, motivated, at least in the case of Mr. Wiley, by a personal interest in the fees that were generated by the exercise, and without regard to the protection that regulatory law was intended to afford retail customers. The judge was more than entitled to reach that finding. Sarasin-Alpen behaved disgracefully in this case in very many respects, and they did so plainly because they were desperate for this business. My learned friend asked the Aunt Sally question of why would they want to mis-sell if they wanted long-term clients? But that's a question one can ask in every single mis-selling case. The reason people mis-sell, I'm not suggesting they wanted the products to fail. No doubt everyone would have been delighted the products had worked, but in the meantime they wanted the business and they were uncaring about mis-selling the product. and they were indeed pushing to get it, even to the extent, for example, if you look at paragraph 100 of the judgment, one can see a description there of the internal communication of Mr. Nair puffing things, even internally, to Bank Sarasin. And you get the same point in paragraph 82. Mr. Nair starts off by telling Bank Sarasin that this is an 80 million client, has 80 million with a local bank in Kuwait. Not actually saying at that stage, internally, that that it's actually just going to be borrowed from ABK. It's all puff. It's what they do. Now, I'm not suggesting D2 ultimately was misled, because they plainly came to know that the borrowing was from ABK, because they were party to all the IPO and the commitment to ABK. But what it is a demonstrator of is the way, again, in which they were desperate for this business, and they would puff things to get it. And that justifies the judge's conclusion comfortably, amongst other things. And the judge obviously was also entitled to place weight on the way Mr. Wali's personal interest in the litigation slipped out in cross-examination, and indeed on the evidence of the AGBCs, which I'll come to. The next point taken by my learned friend was about the claimants giving evidence in Arabic. Now, that is their first language. If they were being cross-examined in detail and at length and by reference to documents, they were entitled to prefer that to happen in their own language. And there's no basis for any adverse inference in that. They never said they did not speak English. There was nothing at all inconsistent with the facts that the meetings were in English, and how the product worked was explained to them in English. And although my learned friend made some play of his Annex 1, which had some extracts in, the passages of cross-examination that are referred to and that we saw, in fact showed Mr. Khorafi giving a clear and consistent and credible explanation of his level of English. And that exactly reflected what he said about it at paragraph 4 of his witness statement. Of course he spoke English, he had conversation in English, he felt uncomfortable with reading and writing, especially complicated business documents, and he felt uncomfortable with complicated conversations of the sort that would happen in cross-examination. And again, this is another area where the judge was ideally placed to consider all this, and it's another instance of the Hausen and Nicolaisen fallacy in my learned friend's submissions. My learned friend next says the judge's approach to the witnesses was unbalanced. Now, I've dealt with all his examples, leaving aside a couple of client classification points I'll come to, with one exception, which I haven't dealt with, and that is the point at paragraph 48.7 of his skeleton, which is a discrete factual point about whether in August 2007 Mr. Khorafi was made aware of a margin call requirement. And the judge accepted the claimant's case on this at paragraph 132 of his judgment. And Mr. Wali it's important to remember or to understand the sequence and the rival positions. Mr. Wali's evidence was that there was a meeting in London at which margin was discussed, and there was a call with Taha, and that's recorded that's at paragraphs 163 to 5 of his witness statement. The claimant's evidence was that it was not discussed as a meeting, but there was a telephone call in which they were led to pay $10 million, but in that call were not explained about margin and collateral shortfall. Now, on this whole area, the first point to note is there wasn't a single minute or similar document that suggested there had been a discussion about margin call. The second point to note is that Mr Al-Khorafi continued to draw money out of his accounts after that date, which would hardly have happened if he'd been aware of the margin call issue. And the third point to note is that when the following year, in the summer of the following year, the claimants were made aware of the problems with the accounts and the requirement for margin, they were immediately up in arms, sought external advice, and had the acrimonious meeting with the defendants that's dealt with at paragraphs 156 to 158 of the judgment. And indeed, yesterday we saw the HSBC minute. So that's the debate. We then need to look at paragraphs 207 to 212 of the judgment.
So, paragraph
207 to 212, where the judge deals with the evidence.
Yeah.
Now, Mr. Taha gave evidence that, contrary to what Mr. Walia said about a call with Mr. Taha, there was no call with him, as Mr. Walia had alleged. So that was unchallenged. And that contradicted Mr. Walia's evidence in his which is recorded in the judgment at paragraph 163. Mr. Al-Khorafi was challenged around this general area to some extent, it's right to say, but it was not suggested, this is the important point, not suggested that his account of a telephone call that he received in his car was false. The judge's point that these paragraphs of his witness statement were unchallenged was in fact accurate. And my learned friend has in fact given you all the references to the cross-examination, so you can check that. Now, in the later passages of evidence my learned friend went to, which he said suggested Mr. Al-Khorafi was in some way trapped, Mr. Al-Khorafi was not saying he was told there was a collateral shortfall or having margin explained, and he didn't differ from his earlier explanation about what was said the previous year. So one didn't really get anywhere, although my learned friend suggests the judge has gone wrong. The judge didn't go wrong, and it was there was nothing, no point of any substance in Mr. Al-Khorafi's evidence. But in any event, as I said, these were all matters for the judge to evaluate. And as regards the conversation in the car, Mr. Nur had backed up Mr. Al-Khorafi, and he was not challenged, just as the judge said in his judgment. So the judge's conclusion of paragraph 212 was justified on the evidence, contrary to the suggestion from my learned friend. So that deals with all the points relied on in relation to their main ground of appeal on ground 1.1. I'm not going to deal with my learned friend's grounds 1.2 to 1.7, because their own case is that these are consequential on ground 1.1, so I'm not going to go to those. There's no independent suggestion that the judge ignored relevant evidence or didn't have material for his findings, and in fact the contrary is true, because the findings that my learned friend lists as being consequential, in fact there's a whole host of additional evidence which justify the judge's findings. The next is my learned friend's ground 1.4, which relates to the judge's findings about the claimant's investment objectives. I've dealt with that already, but three extra points are raised by the defendants in this context I need to deal with. First is the suggestion that the judge gave insufficient weight to Dr. Fitzgerald's evidence that no product existed which would meet the claimant's needs. Now, what's said is that that should have led the judge to conclude that they didn't have those needs. But that's not a good point. The evidence was that their requirements were as they said, and as the judge said, if the product didn't exist to meet them, then they should have been told that and no product sold. But what the argument also overlooks is that Mr. Walia accepted that there were products that would meet those requirements, albeit would carry increased issuer risk. And as I said yesterday, the obvious example is a product structured around a high-yield bond. And And as I said yesterday, obviously the higher the yield, the more the risk, the more the issuer risk. But we are talking here about unsophisticated investors. The next point from my learned friend is the point about their point on the documents, and I think I've dealt with that. There were no documents that were compelling. And the
I think I may have misunderstood you. Assuming that I've got it in my head, keep referring to appeal item 1.1, 1.2. Where are you actually deriving those from?
Sorry, my lord. What's happened is the first defendant put in a grounds of appeal,
right.
ground one, and his skeleton follows broadly his grounds of appeal.
Right.
And my learned friend in his submissions also, with some...
Yeah, I'm not sure I had what I call identified the paragraph numbers of these points. So taking, for instance, the topic you're on,
1.4.
1.4, where is that?
One can see it in the grounds of appeal.
Yes, I haven't got that document open. Unless, can we see it in the skeleton? So
yes, and you can also see it in the skeleton. Let's just take it to a skeleton. Well, I was absolutely right. It is quite difficult. There are an awful lot of grounds and subgrounds.
There are an awful lot of grounds, and this is not an easy document to play with. There's a lot of repetition.
1.4.
Yes.
You will see at page 46 of our skeleton, paragraph 51.
Right.
What I'm going to try to do, and please...
I'm with you now. Okay, thank you.
But please pick me up if I fail. But what I'm going to try to do is when I talk about a ground, I'll try and say what the point is.
Yes.
So that everyone knows what
It's not easy to identify what the individual ground is just from a number.
No, my lord,
Right.
right. So,
So you've dealt with Dr. Fitzgerald. I mean, your simple point is that if it be, and it may be common ground, that what the claimants were asking for was something that could not be achieved, it doesn't follow that it wasn't offered.
absolutely.
And yet he says that, emphasises the need to say so.
Absolutely. And one also needs to be a bit cautious when just asserting it couldn't be achieved. It probably and probably certainly couldn't be achieved with a high-rated issuer, but it was achievable in the market. But you would have to take some significant issuer risk. The next point my learned friend makes under this head is about the documents, but I've been through those. As I say, nothing was compelling. The only readily intelligible product document was misleading, and the judge was entitled to reach the conclusion he did. And the last point is the claimant's suggestion that Dr. Fitzgerald gave evidence that the term sheets and fact sheets provided the necessary information. But again, that ignores the way the evidence ran, because as it showed at trial, the fact sheets didn't give the necessary information and in fact supported the claimant's case for the reasons we explained today. So I was quite surprised to see Dr. Fitzgerald's report trotted out, because that was thoroughly discredited at the trial. Now, we then have a separate point, which is at paragraph 53 of their skeleton.
I'm not sure I'm very sorry.
Yes, I'm sorry.
I'm not quite sure I'm following that point. Yeah. Just say it again.
Yes. So Dr. Fitzgerald says the product was adequately explained in the term sheets and the fact sheets. Now, subject to them being difficult for a lay reader to understand, I accept that in relation to the term sheets. They were accurate, but difficult to understand.
Right.
The fact sheets did not fairly explain.
That I understand too.
Because those are the documents with the calculation that supports the claimant's case about what the product was to provide. So didn't
well, I'm assuming, maybe I misunderstood what you said, that Dr. Fitzgerald was, since having regard to all the documents and making his observation that the matter was clear from them. I agree, whether he distinguished between an expert like himself and a lay person, I don't know. I haven't read Dr. Fitzgerald's evidence.
Well, it's not a big point, but
right.
the point simply is that he was relying on the term sheets and the fact sheets. He was only fair to say that about the term sheets. Those were difficult to understand. It's as simple as that. The next point is paragraph 53 of their skeleton, and which is an independent ground of objection, which is really a pleading point in relation to the judge's findings about unsuitable advice as to credit facilities. What they say is we didn't plead unsuitability in relation to credit. There's a short answer to that, which is that our pleading did make clear that we were criticising the investment structure, which was investment plus leverage, and saying that was unsuitable, and that was paragraph 78 of our re-amended points of claim. The next point is my learned friend's paragraph 54, which is in relation to Mr. Taha, and I've dealt with that, so I'm not going to repeat myself. In that really is all my learned friend's points, and so in conclusion, my lords, I would submit that the claimant's attack on the judge's factual findings cannot succeed and should be rejected. Can I now move to the client's issue? And I'm going to start off with looking at the rules, which you will find at bundle G2, tab 85. Yes, please. Now, one needs 3.2.2, which is at tab 85, page 4854. Is a person, 3.2.2, is a person who the authorised firm has determined, so you need a process of determination, prior to the establishment, prior to the establishment relationship, it's got to happen first, is an individual who, one, has at least £1 million in liquid assets, and has provided the authorised firm with written confirmation of this fact. Two, appears to the authorised firm after analysis, so again a process of analysis, to have sufficient financial experience and understanding to participate in financial markets. And three, separate requirement, has consented in writing to being treated as a client. We then can go on to...
For this purpose, relationship means what?
Certainly any business dealings.
You mean meetings or a contract or what?
Well, really, before any... it should be before anything which resembles investment services are provided.
Right, so relationship means...
If you have meetings about the products and you send documents explaining the products, then you're already providing investment services, right, so you should have done it before that.
You can't go so far as to require some contractual relationship. It must be some non-contractual relationship.
Well,
I'm not quite sure when it gets underway.
Well, what should happen?
These have got to be established prior to the relationship.
Of course. What should happen is...
So it seems to be slightly chicken and egg.
Well, no, my lord. What should happen is you meet the client, you do your client classification, you do your process, you then sign him up to your investment terms of business, and then you provide financial services. That didn't happen in this case. In this case, they started providing advice and giving recommendations, and then along the way, they signed them up on the basis of false information. The timing was in fact one of our complaints, but it's not the biggest point in this case. But it was indicative of the way Saracen does business. 3.2.4 is an important section, which is headed analysis, and that explains the analysis that has to be done in relation to financial experience and understanding. And it reads, for the purpose of Rule 322A, 2 and B2, An authorised firm must ensure the analysis includes consideration of each of the following matters. A, the individual's knowledge and understanding of the relevant financial markets, types of investment and the risks involved, either generally or in relation to the proposed transaction. B, length of time the individual has been active in relevant financial markets, frequency of dealings, extent to which the individual has relied on financial advice from financial institutions. C, the size and nature of transactions that have been undertaken for the individual in relevant financial markets. So just pausing there, my lords. This comes back to my Lord Sir Richard Field's question about does one need to be interested in the type of product or type of services you're going to be providing? And of course the answer is yes, because 3.2.4 is directing you to look at conduct an analysis of relevant financial markets in relation to the proposed transaction.
Well, that's why I'm finding some difficulty with it, how you embark on this task of conducting the analysis before establishing any relationship. Because until you've established a relationship, you don't know what the client wants. But if you've got to decide whether he's fit to buy the relevant commodity, you've got to reach the stage when you've discussed the commodity.
Well, of course.
So it seems to go round in circles.
Well, no, it doesn't really, my lord. I can see how my lord's point might arise if you just had some sort of generic advisory relationship, and then in the future there was a particular product. But what we're dealing with here is the clients coming to Saracen for the purposes of a structured product to be sold on borrowing. So Saracen didn't need to be giving them any advice at all before, in order to understand what it is their role is on this transaction.
On the facts of this case, I can see that it may be that the customer walks in and says, I want to buy a structured product, I borrowed 80 million, or whatever the figure was, I can't remember. And then there would be, on your case, an immediate discussion of the relevant area, namely structured products. But if a client walks in and says, I've got 100 million and I want to invest it, and I need your advice. Now, as I understand it, this requires the firm to determine, before establishing any kind of relationship, whether he is a person, or she is a person, who has an understanding of the relevant financial market. Now, how does that work?
Well, obviously it's fact dependent, but if he just says I want to invest it and nothing more is said, then what they need to understand is whether he has an understanding of investments generally. So for instance, if it's a man just saying I wanted 100 million, a financial advisor would naturally think, well, stocks, shares, bonds. They probably would not naturally think aggressive futures, interesting derivatives and so on. If they wanted to sell him that, then they would need to have a rather more detailed conversation. So
well, they have to do a further determination, actually.
Well, they...
Or when he comes back again and says, I am a client, I now want something different, they have to determine whether he is experienced in the new relevant market.
Conceivably more. Let's take Mrs. Al-Hamad. She comes to Credit Suisse, say, wanting a plain vanilla portfolio in shares. If down the road someone unwisely has said to her, there's a really aggressive derivative I want you to have a go at, it may be that in giving her advice they would say, well, I'm not sure, because we took you on the basis that what we understood you were doing was this rather ordinary share portfolio. We're not comfortable with you dealing through us on something that's different from the basis we took you on. So we're now going to do another analysis to check we're still happy that we can conduct this trade. Of course, one can imagine outlying situations where it might be quite difficult to apply the rules. But here, it's very easy to apply the rules. And what one's trying to get, what the regulatory body is trying to do is lay down a practical, rule-based system for people to follow. Here, it's quite obvious, since they're only coming to Saracen for putting together these particular products, that Saracen has to conduct an assessment of their knowledge and understanding of these relevant markets and relevant types of investment. And indeed, they need to think about, they've been under B, the length of time the individual has been active in relevant financial markets, frequency of dealings, extent to which the individual relied on financial advice. Now, that last financial advice point picks up another point raised by my Lord Sir Richard Field, what's the significance if previous investments have been done on financial advice? And the answer is that will generally be a negative indicator. So again, Mrs. Al-Hamad arrives, she only has, although she has traded in shares, she's done so with an advisory portfolio. So she just has bankers who in the past have advised things, and she said yes. That is a negative indicator of her financial experience and understanding. And again, that the firm will need to take that into account when considering whether to accept her as a client. Because if they're just going to give her the same again, and they're just going to advise her too, that's probably all fine. If the intention is she's going to go off on a flyer with options and futures, then that's not fine. So it's a workable and common sense system. And one also has D you need to worry about, E, composition and size of the individual's existing financial investment portfolio, and F, any other matter the authorised firm considers relevant. Yes, I mean, when I say D is not relevant, it's not relevant in the sense that there's no suggestion, couldn't be any suggestion that any of our clients had any qualifications relating to the financial markets.
See, the word relevant sits on top of the phrase either generally or in relation to the proposed transaction. And I find that a little difficult at the moment.
Well, I think it does work. So can I give an example of structured products? Let's say these clients did have experience of structured products generally, but what Bank Saracen was selling them was a fairly exciting and quite different structured product. One would want to look at their relevant experience in the relevant area, or you could look at their experience in the particular product. Now,
but suppose a putative client says they've won the lottery and they want investment advice. What's the relevant financial market in those circumstances?
Well, if it was
generally or in relation to, certainly it could only be either generally.
I think at that stage it would only be general, and one that maybe you would need to go back just have it completely broadly. It would just be the financial markets. I think probably in a situation of that kind, in practice, one would want to establish, as I said to my Lord Sir David Steele, what type of markets they were familiar with. So, as I said, naturally stocks and shares would be fine, but you wouldn't expect if someone just came for 100 million and wanted a general advice, that to lead to advice about difficult, complicated derivatives. And if it was going to lead there, you would need to have that conversation and find out their experience in that area.
Yeah. Well, it strikes me some of these rules are written as the lowest common denominator of performance.
Well,
any competent firm would regard this as the bare minimum.
Well, of course, yes. Yes, and that's the thing. I mean, I quite accept there might be some cases where a firm might find things quite difficult to know what process to do, but this just isn't this case.
Yeah.
This case is quite clear what had to be done. And then my learned friend took you to it, but 3.2.5 and 3.2.6 also makes clear you need to have systems and controls in place and to keep records of the process including the process of analysis. And that just simply wasn't done.
Yes, the verification is at a different stage, isn't it? They must verify prior to undertaking investment business that the person is a client, i.e. it's an ex post facto analysis. That's you.
I'm sorry,
You first establish he's a client, and then you've got to have controls in place to verify he is a client before undertaking investment business, which I assume means you just look in the drawer. That's extraordinary provision.
well, I'm not sure I've repeated that.
Have I misread that?
I think probably you're supposed to read that as saying the systems and controls must govern the process.
No, but this is prior to undertaking investment
Yes.
business, not prior to establishing a relationship.
But I think what it's saying is there has to be a process of verifying prior to undertaking investment business that the person's a client.
Right.
And you've got to have systems and controls in place to do that, to verify it. So in other words, you've got to set up a system to conduct the analysis.
Yeah.
And then so you've got to have control over the process. It's not brilliant drafting. And then record keeping is rather clearer. You've got to keep records of the verification process. And in fact, that word verification process rather helps the construction I suggested to my lord, because it is clear that what one's looking at is a process of verification. And you have to have records to show that that's been done. And of course, if you did have records to show that that's been done in this case, you might be in a different position. I'm just reminded by Mother Julia that one always needs to bear in mind that when looking at 3.2.4, but at the relevant time, this was, of course, not a retail jurisdiction. So when postulating the sort of man off the street coming in with his 10 million or whatever, one needs to keep in mind that a lot of clients may just need to be turned away.
Understood.
That's the rules. Against that, I want to just briefly go through the facts. The sequence of events is the claimants were, at a date which is disputed, sent out account opening forms, which they signed and sent back in the form that my lords have seen, tab H1121, with neither the box ticks nor the questions in Annex 1A answered. And it's now not disputed that the claimants didn't fill those details in. Someone did, and because we have the completed forms in the bundles, and it was the completed forms that the defendants had in their own files. I've made the point about when the litigation began, the defendants tried to suggest that the completed forms were the ones which the claimants were bound by.
This is a long way down the line. The meetings in April and the subsequent meeting, I think in London, I can't remember,
Yes.
In May, had already taken place before this form was, at least in its final version.
My lord, yes.
Yes.
I mean, the
So
filling
this is, as you rightly say, on any view, the relationship had started a very long time before that document came into existence.
quite.
And the account opening form is the contract, is it?
Yes.
And it's your case that the contract is contained in the form which has no manuscript on it.
Well, that's what the judge has essentially found, and I'm
not sure he specifically finds that, but yeah.
I think he does, because I think you can tell he finds that because of his treatment of paragraph 7 of the form, where he says we're bound by that for the purposes of consent. So I think he is finding that the incomplete form
Right,
is the
okay,
contract.
thank you.
And I'm not appealing that.
Yeah, right. So the incomplete form is the contract if there is a contract.
Exactly. Now, and as I've said, and this isn't just a jury point, it's quite a significant point. The defendants did try to shut these claims down at the beginning of this whole process, beginning of this litigation, the letter before claim stage, on the basis that these completed versions were the claimant's documents.
And they can only have got that assertion
From
someone in Sarasin-Alpen.
Exactly.
In short, from Mr. Wilder.
Exactly.
Or Mr. Now, I suppose.
Exactly. And I cross-examined Mr. Wilder about that.
Yeah.
And he accepted, Mr. Wilder accepted it was on his instructions. Well, that's what my learned unit says. I'll check that. I'll check that. And the reason I say it's not a jury point, it is significant because the breach of the rules is what put the defendants in a position to make that assertion. And it was only by luck that we had the versions we managed to find the versions with the post-it notes that were actually sent to us and which are now in the bundles. If we hadn't had those, we would have been in some difficulties in the litigation. Now, my Lord, the next point is a short point about the information forms being hopelessly incorrect. I wonder if that's a point I might pick up at 2 o'clock.
Yes, well, we'll take a break. So I just mislaid the cross-reference to the account opening. Oh, it's H2121, isn't it? 121. No, that can't be right. H1, I suppose. Yeah. Have some refreshment. Thank you.
All rise.
Well, I think which you have to read on.
Okay, fine. I'll take it to him. Can you give me So what was it, day 5?
Page 182.
D2. Yep. I'll just get him to read the whole thing. Shall I go down to line 14 on date 183?
Looks like that's the end of it. I'm just reading on being that's it. So I think it goes off into a different.
To line 3.